In this video, I'm joined by Lisa Neeley. She's an attorney out of Boston who has been working on the Dermody case for 6 years now, I believe. She's had this case for a very long time. And at this time of recording, it's currently being considered on a writ of certiorari up at the Supreme Court. So just a little background about this case is it started out of a request by the state of Massachusetts to get paid out on a spousal annuity. Lisa challenged that. She was victorious at the initial level. It didn't go through administrative hearing because it was a request after the Medicaid recipient had passed away. So it went directly into the lower court. She won at the lower court. The state appealed that up to the appellate court. They overturned the lower court. She appealed that again to the Superior Court there in Massachusetts, where the state again was victorious. This created a split in authority, and so she filed a writ of certiorari at the U.S. Supreme Court with help of local counsel up there in Washington, D.C. And so in this video, she talks about what that process has been like, once in a lifetime opportunity to take a Medicaid case all the way up to the U.S. Supreme Court, and then share some insights just about generally litigating Medicaid cases, as that is a part of her practice. So join me while we discuss with Lisa what this experience has been like. Hey, Lisa, can you just introduce yourself and your law practice and how it might be a little bit different than just a traditional Medicaid planning practice?
Sure. My name is Lisa Neeley, and I'm a partner at Rubin and Rudman in Boston. And I'm an elder law attorney, and I've been an elder law attorney for my entire career. What I tend to specialize in is Medicaid appeals and litigation. So I do obviously my fair share of typical Medicaid applications, but I tend to also handle a lot of appeals. We have a really fairly aggressive Medicaid agency in Massachusetts, so there's a lot of denials and estate recovery litigation, and I've really taken that on as part of my practice. So I am in court quite a bit, and I've handled a number of appeals that have gone up in state court in Massachusetts. So that's where I think my practice differs from the traditional elder law practice.
Absolutely, yeah. And so with the case that we're discussing today and your experience with the Supreme Court is the Dermody case, how did you get hired in that case? Kind of where did you come in for that case? What was your original scope of retainer, your scope of services that
Yeah.
you were hired to perform?
So that case, the Dermody case it was around 2016 or 2017. So it's been going on for quite some time. And it started as it was a post-Medicaid application. So the Medicaid application had been handled by another attorney who had also worked with the family to set up the annuity. So I became involved in that case after the community spouse passed, and the Medicaid Mass Health Agency asserted a claim for recovery against his annuity to essentially reimburse themselves for benefits they paid on behalf of his spouse. So at that time, when that claim had been filed, that is when I got involved in the case.
And then what type of considerations did you discuss with the family as far as the administrative appeal goes, and then going into the different courts that you had to appear in front of?
Yeah, so it wasn't the Dermody case didn't start in the administrative appeal process, and that's where I think it's a little bit different than other Medicaid appeals that I've handled with denials for eligibility. So for
Right.
those, at least how we're set up in Massachusetts is when you have an eligibility issue and you receive a denial, like say for a trust, you're going to be in the administrative appeal area first. Some states, I think, do like a separate administrative agency that handles appeals. In Massachusetts, it's all handled under the Board of Hearings. So they're actually under the umbrella of Medicaid. For Dermody, because it was a post-death case and there was no like a challenge to eligibility, they were just seeking recovery of benefits. And Massachusetts doesn't have a mechanism yet to start that at the administrative level, although we're trying in Massachusetts for some of these estate recovery cases to start at the administrative level.
Okay.
For Dermody, it started as a declaratory judgment action in the Superior Court in Massachusetts.
Okay.
So it was essentially me filing a complaint for declaratory judgment, asking the court to determine who the correct payee or beneficiary was of the annuity in Germany. So that's how that case started. So it was a little bit unique from that perspective, as opposed to my other, appeals that go
And
through.
then once you got that judgment, can you just talk about a little bit what happened at that level, and then kind of what happened with the appeals after that?
Yep. So I filed the declaratory judgment complaint against both, and the parties to the complaint were my client, Lori Dermody, who we believe is proper beneficiary. And then obviously Mass Health and the insurance company, who is nationwide. So we basically filed that asking the court to declare who the proper beneficiary was under the annuity, because the primary beneficiary under the annuity was the Commonwealth of Massachusetts to the extent benefits paid, with no other language.
Right.
The spouse, the institutionalized spouse, wasn't named anywhere in the annuity contract. Um, so that took quite some time to actually work its way through Superior Court, and it was ultimately resolved on summary judgment.
Okay.
So we asked for summary judgment to be entered in Lori's favor, declaring her the proper beneficiary of the annuity contract. And I prevailed at the Superior Court level on that issue. And the Commonwealth was ordered, they had actually already received the funds from the insurance company.
Okay.
So they were ordered to pay those funds back to Lori, which they ultimately did do after some, more legal filings.
And then did they appeal that decision to the appellate level?
So yes, so then what happened was they then appealed that to the appeals court.
Okay.
In Massachusetts, we have like an intermediary appeals appellate court, and then we have the Supreme Judicial Court.
Gotcha.
So the case actually was in the appeals court for some time. And then what happened was there was another companion annuity type litigation matter that had been brought up to the SJC. So then I requested that the SJC also essentially combine the cases and hear my case, the Dermody case, with they're called the Castle Mondor cases. And those are also, they are all consolidated as well for purposes of the what's going to happen with the Supreme Court too.
Okay. So when you decided to take that even up to the US Supreme Court, what was that conversation like with your client?
So yeah, so I'm working with an attorney in Washington, DC, at a really reputable firm, and his name is Adam Unikowski. And he is like the attorney of record for the Supreme Court. He does quite a number of appeals there. Um, so the conversation with my client was interesting.
I'm sure.
She was like, obviously I can't wrap my head around this, and so forth. And really why it's a case that they could consider for cert, or why it's a case that could be considered for cert or could be appropriate, is because there's a split of authority um, in how courts have interpreted this annuity payout or annuity beneficiary designation language. So like the Sixth Circuit um, in the Hughes case was very favorable to our position, and it basically said that there's nothing definitive or in the federal statute that requires like a community spouse annuity when the community spouse dies to pay out to reimburse the state for the institutionalized spouse, and there's no requirement that um, the beneficiary be named with respect to the institutionalized spouse's recovery. And then obviously Massachusetts differed from that, the Supreme Judicial Court decision where we lost. So it's, legally it's a great case from that perspective. So I was just, talking to my client about it, and, she was on board, and The other clients were on board as well. So we'll see, we'll see what happens.
And then what's the for those of us that have never come near or sniffed the Supreme Court, what's it like to what's the procedural process to actually file a writ to get that case taken up?
So that is, and again, this was all new to me as well. So that you file a writ of cert, petition. It's essentially like a full memorandum, explaining why, which Adam prepared, explaining why it's a good case for the court to consider, like the split of authority, things that they look at apparently in deciding whether a case is something they should weigh in on. And also explaining why you think your position is correct. But my understanding is at that level, it's more, explaining why it's a good case for them to consider among all the other cases they, get for review every year. Um, and then, the state gets service of that. So you have a definitive time period to file that, which is, about 90 days. And then the state gets a response time. In our case, they initially declined to respond. So they would file what's called a waiver of response, which parties, I guess, can do because it is very time consuming to, respond to these petitions. And then what happened was then the Supreme Court said that it ordered them to respond. So they obviously took a look at it, or their clerks, and they ordered them to file a response to that petition, which they ultimately did. And then it was considered, in the pool of other cases they were looking at. Should they grant cert? Should they deny cert, et cetera? Once
And
those responses were in.
and what kind of support did you get from the local NALA chapter in this particular phase of the case?
So the local NALA chapter, what they contributed was an amicus brief,
Okay.
which was, obviously extremely helpful at the cert level, explaining why, this was an important issue for the court to consider, that it wasn't just something that impacts Massachusetts, and it's not, it's a federal issue. I think at the time this was filed and the Commonwealth had pointed out in the Supreme Judicial Court proceedings that there's like 30 something cases in Massachusetts percolating, and that this is something that impacts every individual potentially applying for Medicaid with a spouse in every state. So just kind of explaining how it's a wide ranging issue that they should weigh in on. So that was like a great brief contributed by Mass NALA.
So with I know you have local counsel up there that practice in front of the Supreme Court all the time. Do you go to Washington D.C. a lot? Are you appearing in front of the Supreme Court? Kind of what's your involvement at this point?
No, this is new to me. I mean, this is like I probably view it as like it's probably like a once in a lifetime thing. So if it gets in, I will go,
Okay.
and the local council, Adam, will argue it, but I will get to go, and, be there for the hearing if it gets in. I've, been to Washington just, the latest, step was they asked the Solicitor General for an opinion about that, about the case and whether they should grant cert or not. So that's where the case is now. They didn't deny cert. It was considered out of a pool of like 1,000 cases, and they denied most of them. And they picked my case, the Dermody case, and then two others where they were going to weigh in on, ask the Solicitor General to provide an opinion on whether or not cert should be granted. And then they allowed just a small number of cases for cert.
And
So we don't know yet, yeah, whether it'll be taken, but it's kind of weeded out over a number of cases. So it's been an interesting process to like be part of, and I definitely think it's like a once in a lifetime.
yeah, I was looking at that last step, that Solicitor General, the request for their opinion. Can you talk a little bit about what that's all about? That one seems a little bit unique, where the court's ordering a government attorney, I guess, to say, is this a good idea or not? And kind of
Right.
what you're expecting from that and what's kind of the timeline on that particular step.
Yeah, I mean, obviously, like, because this is a first and probably maybe a last for me, it's just a new learning experience. And that they apparently the court picks a number of cases where they maybe want like a opinion from the federal government. What I can surmise, I mean, obviously don't give the reason for that. I mean, maybe because it really is a federal law issue. And this was a state court decision, so it's an appeal of a state court decision. And, perhaps they want the federal government weighing in on, whether or not this is an important enough issue for them to take up. So that's kind of what I can surmise, and we don't know the timing on that, like, they will do a brief and, provide an opinion on as to whether or not cert should be granted, and apparently they file that at any time, so there's not really, like it's not like 60 days or anything of that along those lines. It could be a few months, it could be in the spring, we don't really know. So when that's filed, my understanding is then it will be, considered again by the court, whether the Supreme Court should take the case or not. They'll look and then they'll make a final determination at that point.
And you don't have any idea when that could be or kind of what the timeline of that could be. It could be like next year or a year from now, or kind of what is the
I don't know. I
expectation?
think what the local council, I think probably, it would be like for the end of 2024, like, before the summer session, before their term of 2024 concludes. I apparently, but I don't know the timing. I'm assuming they can take as much time as they need.
Right. Or the Supreme Court. What's your biggest takeaway from this whole experience that, like you said, once in a lifetime opportunity here?
Right. I mean, it's just been really interesting. It's just kind of if I look back on it, you kind of get cases every once in a while, or they start out a certain way and you can't really predict where they're going to end up. So, I mean, I think it's really interesting from that perspective. If I think back like years ago, I started this case and I thought, oh, I'll file a declaratory judgment and then that'll be like the end of it. I remember initially when I filed the declaratory judgment, Mass Health Legal Counsel initially filed a motion to dismiss because they
Wow.
thought the issue was so clear cut. So I did have to deal with that first, which is just when looking back on it, that is kind of an interesting twist to how it began, and now it's still going on and being considered at this, very high level.
Right.
So it's just been like obviously a great experience, something you think about in law school, like,
Right.
I'm reading those cases and being like, well, how did these cases even get here to the Supreme Court? And what kind of cases did they pick? So from that perspective, it's just been, very enlightening and interesting. And also just, as an elder law attorney, is like from a practical perspective, because I was talking about this case to at our local probate conference. And I'm like, this isn't practical because, this is a probate conference and we're not gonna be all running to the Supreme Court, but it's just interesting, from a legal analysis perspective. Like if you pick out issues, maybe these are some things that, may not be, so clear cut, especially in the Medicaid world. I mean, there's so many things in that Medicaid statute that, you representing your clients as an elder law attorney, like you should look deeply into what your local Medicaid agency is demanding or denying or asking your clients to do. So I think from a practical perspective, that's like the biggest takeaway for elder law attorneys. And we've seen that across the board in Massachusetts, not just with these annuity cases, which we've had a number of them, also with trust cases. We have a lot of irrevocable trust litigation in Massachusetts that's gone up to the high levels, the Supreme Judicial Court. And just, the state agencies making decisions that aren't always on par with how the Medicaid statute is supposed to operate. So, I think it's just, it's a complicated statute. That's the overlay, and then each state implements it in different ways. So, just understanding that this is a complicated area of law. I think you're doing litigation. There's like a Medicaid case out there that calls it like an incomprehensible statute that nobody can understand. So,
And
there,
it's like navigating through rocks or something in that.
yeah, like a labyrinth of
Yeah.
miasma. So it's a complicated statute. So just, never kind of underestimate that, and always look into what Medicaid in your specific state is asking your clients to do. And, is this correct? So
And when you identify that the the agency has acted in a way that might not comport with the intention of the statute, how I know a lot of elder law attorneys have a hard time convincing their clients usually to take that up to the next level. They don't want to do that. What are the types of conversations that you're having with your clients as they're considering, let's say they got a trust denial, and it's not, it's an irrevocable trust properly drafted. There's really not a problem with it. It's just that the agency's kind of throwing that they don't want to set a precedent with these types of trusts or something like that. I know that's happened in a number of states. What is your approach with the clients to say, hey, we really need to fight this?
yeah, so I think like with the Dermody case, I mean, it's such an outlier. It's not like it really is such a unique issue and an outlier. That it's something obviously everyone struggles to kind of interpret that statute. But, I think with like the irrevocable trust litigation, which is much more common, and I know many other states have dealt with that, um, is, like when I was doing a lot of the irrevocable trust litigation, which I've handled, I always looked at, and I know I worked obviously really closely with the Mass chapter. Look at the trust document itself. I know that there was a lot of, we were nervous about making bad law or making the law worse some way or making it
Right.
worse for clients. Just looking at the trust document itself and making sure that it actually was like a good trust and that it was just really Medicaid kind of interpreting the statute incorrectly and saying this is countable when it's not. So, those kind of considerations, making sure you're not appealing something that, actually is a proper denial, because I've seen those trusts as well. Um, and then, just having the conversation, obviously, with the clients, like this was a good plan. You have your house in here, or, there's a house in here that's very valuable. And if you kind of go along with what Medicaid asks, they're getting a lien on that it really should be protected. And that's allowed in the Medicaid statute. What we saw in Massachusetts with the trust really was like a total disregard of trust law, like, and just kind of going wild with what the any circumstances test and expanding that beyond all normal bounds. So, most clients obviously were on board with that. They didn't want the idea of, um, Medicaid, making up reasons to attach people's homes.
Yeah, that makes a
It's
lot.
just like, filtering out what a good case is, but not being like afraid of litigation.
Yeah, that makes a lot of sense, and especially kind of honing in to what is the ultimate circumstance for the client. This is what could happen, especially if you're in, an aggressive estate recovery state. If we don't challenge this, that could open up those assets to collection by the state as well.
Correct. Right. Yeah, because we also have, in addition to, denials, we also have a really aggressive estate recovery program in Massachusetts. So
Yeah, that's really smart. Anything else that you want to share before we wrap up?
yeah, I don't, just anyone, I'm always really receptive to attorneys, like even in other states. They have questions about litigation. I know I've been contacted by attorneys in some other states that have had like a lot of problems with irrevocable trust denials, and just, not to be afraid, to work with your local NALA chapter and see collectively if you're experiencing a large number of denials. I kind of think every state like picks, what they want to go after. But it all kind of has to be resolved under the same statutory interpretation. So just to kind of, maybe partner, if someone's newer to litigation, partnering with like a litigation counsel, that can maybe help navigate some of those complexities if it's a case that's appropriate for that. And then working with the local NALA chapter. So, and I'm always open for like questions or people reaching out and email and things.
Oh, that's great. Thanks so much, Lisa. I really appreciate it.
Okay, thank you.